Good afternoon, everybody. Sorry that I've got a weird light situation going on. There's not much that we can do. Thank you very much indeed for joining us today. We know that this is incredibly unusual times for everybody, but we didn't want to give up and not hold this event. So we've gone for the virtual approach. It's a little bit disconcerting for us because you can see us and we can't see you. But hopefully you've got the facility to ask questions at the bottom, and we will try and answer as many questions as we can in the time allowed. We're going to proceed for the next 30 minutes or so, and in particular we are going to be discussing personal injury and clinical negligence law. Now, I hope that you're all still listening and haven't muted us listening to Matt Hancock's current dribble in the Commons. So just to introduce myself a little bit more, my name's Louise Green. I've been a barrister for about 11 years now, and actually came to King's Chambers late. I did pupillage at a different set of chambers and came over to King's because of the incredible work that they do, and I wanted to improve myself and thought King's was the best place to come to. Before starting at King's, I'd never done any clinical negligence work whatsoever. And now, kind of 5 years in, I'd say 80% of my practice is clinical negligence. I'd always wanted to be a barrister and followed the traditional route, so university. It was BVC when I did it, but BPTC, as I think it's now commonly known, and didn't go to a red brick university either. So I think that the bar is much more diverse now. I just want to encourage as many of you who've got the aspirations to give it a go and see where you get to. The other person doing the talk today is my lovely colleague Richard Livingston, who also does a mix of PI and Clin Neg, but in addition to that has a quite heavy focus on disease work, and he's going to talk a little bit about that as well. So Richard's going to introduce himself and then we'll get started about what personal injury law is, what clinical negligence is, what the types of things, types of cases that we do, and we'll hopefully inspire you all to become PI and Clin Neg practitioners, because we think it's the best part of the law.
Absolutely, absolutely. Thanks, Louise. I just to say a little bit about myself. I went to school in Glasgow, didn't do Scots law, decided to move to Manchester and did an English degree. And then did a law conversion at what was then called the University of Law in Chester, and then converted to the bar in Manchester. Unlike Louise, I did my pupillage at King's. I'm fortunate enough to be able to say that my former pupil supervisors are now a High Court judge. That's Nigel Poole, and a QC, Sarah Pritchard. And my work is split approximately 50-50 between clinical negligence work and personal injury / disease work. I've just seen a question come up saying, is the work disappearing? Absolutely not is the short answer to that.
I hope not. We'll be able to pay our mortgage if it does.
We'll be finishing at 20 past. Absolutely not, and we'll go on to explain why there's so much of it around at the moment. But we thought it would be quite useful to talk about what the best and the worst parts of the job can be.
Absolutely.
Your thoughts? Yeah,
I think that this job, and particularly personal injury and clinical negligence, is incredibly rewarding because it's really diverse. Anybody can be involved in some sort of accident, be it a brain surgeon or a builder or a mum or any, you just deal with such a wide range of people. Similarly, anybody can be the victim of clinical negligence. So it's really, really diverse. No 2 days are the same, I think it's fair to say. The difficulty, or one of the main things that I find, and I'm a mum of one and one on the way, and I think one of the hardest parts of this job is that it's quite difficult to plan, because you can get last minute briefs, particularly with clinical negligence. They're the work can be volumes and volumes of medical records. So it takes a lot of time to prepare. It's certainly not a 9-to-5 job. But the flip side of that is it equally can be very flexible because you're self-employed. You can dictate to some extent whether you want to work 5 days a week or not. Similarly, I don't work on a Friday. I have that as kind of mummy and daughter day, which I enjoy very, very much indeed. And you can kind of set your own pace. So obviously, as a mum, I can kind of slow things down a little bit. And once my children are older, I've got the ability to pursue and push on in my career. Richard, what are your views about all of this?
I find it much easier to plan than it was initially. I mean, you remember when we started out, you'd quite often get a trial sent to you the night before. That doesn't happen so much now. It's far easier to plan, I find, the more senior you get. The hours can be punishing. I find they can be anything from 50 hours a week on a fairly good week to something closer to 100 hours, sometimes 6.5 days a week if you've got a trial starting on the Monday. Someone has just asked whether this is an area of practice where you have a good work-life balance. I don't know what Louise feels about this. I have to say, I think you have to be pretty disciplined to ensure that you do get that work-life balance, but there's no reason why you couldn't have it. I just wonder, Louise, you said that you have a Friday booked off. Is that set in stone, or do you find you're having to work at weekends to make up for working the Friday?
No, I think that's true. So I do tend to have Fridays booked off. Famous last words, I've got a 3-day trial next week that finishes on a Friday, so it doesn't always work out that way. In terms of work-life balance, I think that it can be had in this area of law, absolutely. I think in any area of law, and the question that ties in with this is kind of percentage of time in court and time behind the desk. I think that contrary to areas like crime, for example, where the majority of your time is in court, quite a lot of your time in personal injury, particularly clinical negligence, is spent doing advices, drafting pleadings, preparing for conferences. And so to that extent, you can get a good work-life balance because, I can put my little girl to bed at 7 o'clock and then do a few more hours work. I'm not on a set time frame. So that gives me some better work-life balance in that I can, see her when she comes home from nursery for a couple of hours, pop her to bed and then carry on with my work for the day, which is quite a common thing. Similarly, if you've got, a 5-day trial booked in your diary and it settles the week before, on the one hand, you panic because you think, gosh, that's 5 days of income lost. But similarly, that's where you take back some of the time that you've perhaps missed having worked some weekends or evenings. So I think that overall you can get a good work-life balance. I think you just have to be quite strict with how you apply yourself. And as Richard says, very, very disciplined in the work that you do, making sure that, you do take the time when you need it, but equally realising that this is such a privileged job. It's an absolute privilege to do the job that we do. And we get paid handsomely for it. So, you've got to put the work in if you want the good reward, in my humble opinion.
I also very much enjoy the camaraderie of the job, which I've missed a huge amount during lockdown. One of the very nice things about the PI bar in particular is that you do tend to know most of your opponents. And there's usually quite a good crack between us. It's a very rewarding aspect of it because you are against the same people a lot of the time. I don't know whether colleagues in chambers have raised that as a feature of commercial work and planning work. I don't know if it applies to quite the same extent, but it's certainly something that I enjoy. But there's no getting away from it. As you become more senior, there's less time spent in court. The higher value stuff, as Louise says, usually settles. If it doesn't, then someone's messed up along the way. That's the way I've always looked at it. But as a more junior practitioner, you do a lot of what's called stage 3 hearings or disposal hearings. Those are hearings where the only issue in dispute is not liability, but how much the claimant should recover with damages. You'll do a lot of fast track trials that involves cases where the value of the case is less than £25,000, and those do tend to fight in court, and just straightforward applications.
Yeah, no, I agree with that. Why don't we talk a little bit about the different types of PI and clin neg work?
Time's getting on a bit.
There's really good questions that have coming up on the side, and we'll deal with those in a moment. So from our point of view, I think that most people that enter the personal injury clinical negligence bubble probably start off with doing a lot more personal injury work, because it tends to be slightly lower value unless you're dealing with the catastrophic injuries, which we'll come on to. But personal injury can be anything from road traffic accidents, accidents at work, highways, slips and trips, accidents kind of on the public highway, even down to the more bizarre animal cases, so dog bites, I think horse kicks. We've had it all. So you do often start out doing that type of work because it's slightly lower value, as Richard says, fast track trials under £25,000 that resolve in a day. Whereas the clinical negligence aspect, I don't know if many of you have watched Botched, it isn't like that at all. But it can be anything from operations gone wrong, failure to diagnose cancer or delay in diagnosing cancer, sadly baby death cases or baby injury cases, so obstetric injuries, Cauda-Equina syndrome. It's just everything really from a medical setting that has gone wrong. And we act for both claimants and defendants. I think I've got a slightly higher claimant bias, whereas Richard, I think you perhaps have probably got a slightly bigger defendant bias. And there are various benefits to both sides of the coin. I know when we did this seminar last year, somebody said, well, what do you prefer, claimants or defendants? And we both prefer our respective biases for different reasons. So I quite enjoy doing claimant work. I think claimants are obviously very invested, and I find it's perhaps slightly more rewarding doing claimant work because you get the case from the start, you can dictate the route that the case will take, you have much more input doing claimant work, particularly clinical negligence work. Whereas I think from a defendant point of view, you don't always have that same input because the public purse, often dealing with NHS trusts, the public purse has to be controlled slightly more tightly. And so your input might be dipped in and out of. The major benefit of doing defendant work, which Richard will probably say, is that you are guaranteed to get paid. Whereas the majority of claimant work is what's called a CFA, which means no win, no fee. So if you take a claimant case on and you get all the way to the end of it and you don't win it, you don't get paid. But if you do win it, the costs that you can recover for claimant work are probably higher on average than what you would recover for defendant work. So actually, it probably evens itself out over the course of your practice. And Richard, what's your view about kind of claimant defendant work? And I know you're going to talk a little bit about disease as well.
You're absolutely right, and I wholeheartedly agree. There's nothing more rewarding than getting a good result for a claimant. I think I said the last time we did this that I found doing defendant work a lot easier, and I think you disagreed with me on that. I find it a lot easier because I find it a lot easier to knock down a case rather than to build one up. But one of the really great things about being at King's and doing clinical negligence work is that you have the opportunity to work for both sides. So in theory, not that barristers are, but you're not partisan or anything like that. But it's really useful to be able to see where the other side is coming from. And that, I think, is the absolute key to running a case properly. You need to focus on the good points that you have and the bad points, but you must always be alert to the way the other side is going to run the case. And I think if you exclusively act for one side, you lose the perspective of how the other side's going to approach the case. When I started out doing clinical negligence work, I did very little defendant work. I'm not quite sure why it's been the case that I've moved over to working almost exclusively for defendants, but it's given me a very useful insight. There is a variety of clinical negligence work that you don't necessarily see in personal injury work. It's probably right to say that no two cases are the same. The same types of issues arise. For example, as Louise touched on, Cauda-Equina syndrome is a significant area of litigation at the moment in clinical negligence work. And the extent to which clinical guidelines are adhered to and followed is an issue that comes up repeatedly. Similarly, with delayed diagnosis of cancer, the data relied on is often contentious, and that those types of issues tend to translate from case to case. But with that in mind, there is a huge amount of reading. So even though the factual matrix might be similar, you still have to spend a huge amount of time going through detailed medical records. And I think it's probably fair to say, if you're not a details person, it might be an area that you'll struggle with. Is that fair?
No, it is, and I have to say, certainly when I started out doing clinical negligence work, I remember I would get, you get those first few briefs, and I've got no medical background whatsoever, and weirdly you become almost dangerous doctor. I call myself a dangerous doctor. I'm forever diagnosing friends now with things that I think they've got, or myself, which is terrible, because you acquire that dangerous bit of knowledge doing this type of work. But I remember getting those first few briefs and I'd think, God, what on earth is Cauda-Equina syndrome? And it could take me 2 hours to just get through the instructions, where I was circling all the words I didn't understand and getting a medical dictionary or Google and Googling all the different terms. And I think that just comes with experience, that once you've done a couple of Cauda-Equina cases, for example, or a couple of obstetric cases, you suddenly work out how to look at a CTG, so which is the trace that babies have when they're in the womb, and you can detect if things have gone wrong. So you acquire that knowledge as experience goes on. But it is a terrifying prospect, that first clin neg brief, and you think, oh my goodness, what on earth is the anatomy of the body, and how does the hip bone connect to the thigh bone? And it can be quite daunting, but your experience comes through in those circumstances, and it takes a lot of time at the start, and I think the longer that you do it, the easier it becomes, because you just become more familiar with the terminology, more familiar with the biology, more familiar with the medicine. So was just looking at some of the questions there, and one of them, which is a really good one I think at this point, is how we manage to stay emotionally distant to some of the hard-hitting cases. I think I probably would have a different answer to Richard about this, which is, I'll be completely frank, there have been cases, particularly cases involving babies for some reason for me, where you can put your serious barrister hat on and you can go into a conference where a mum has perhaps lost a baby, terribly, terribly sad, and you don't shed an ounce of kind of, not emotion, because it's important to connect with the client, but you don't let them see that side of you. And there've been often times I've come away from a conference and had a little cry, and I'm not ashamed to say that. And I think if you didn't have that passion for your client, you wouldn't do as good a job. You have to sometimes put yourself in their shoes, but not put yourself so much in their shoes that you forget the legal aspect of it to try and think whether you'll win. Because a judge has to look at a case, whether it's a baby death or otherwise, and have huge, huge sympathy for a claimant, but equally might think, well, legally this case isn't successful. So you've got to try and find that balance, I think, between having emotion to connect with a client and for them to trust in your ability and understand their position, versus being able to pop that to one side when you need to analyse the legality of the case, to make sure that you think you've got a case that you can take forward. So that was a really good question. Richard, I don't know, you might be harder than I am. Being from Glasgow, I don't
know. It can be difficult. There's no getting away from it. It can be extremely difficult. I suppose I've always thought to myself that clients don't want to see the emotional side, and however difficult it might be, I don't think it helps the client, and I don't think it helps you. It sounds terribly artificial, but as Louise has demonstrated, I think if you do feel that you'd find dealing with the worst point in a lot of people's lives, then you probably have to find out some way of suspending that emotion if you can't get rid of it altogether.
Yeah, no, absolutely. Another question that was a good one that's come up is, does it ever bother you that there's sometimes a negative stigma around PI and Clun Neg called, ambulance chases? It doesn't bother me one jot. I think that the minute that you start doing this work, whether you are doing personal injury or whether you're doing clinical negligence, you're actually making a real difference to people's lives, whether that's a claimant or whether that's a doctor that's been accused of something, which can have such a huge detrimental impact to their practice. That I just think it's one of those things that you see, it doesn't really impact on me. I think the work, particularly that we do at King's, is of such a quality and such a level that it doesn't really bother me in any way, shape or form. Richard, I don't know if you take the same view of that. I don't think at King's we can be classed as ambulance chasers, really, can we?
You do get it quite a bit though, don't you?
You do. I think as long as we're all working hard, it doesn't really bother me to any great extent, I have to be honest. Richard, you were going to talk a little bit about disease, because you do some disease work as well, which I've steered slightly away from as time has gone on, but go ahead.
What's meant by industrial disease work? Well, it's any disease that originates as a consequence of exposure to a harmful substance at work, and that's how I've always thought about it. Usually, the pathway into that line of work begins with doing noise-induced hearing loss work, and cases involving hand-arm vibration syndrome, a vibration-induced injury, and then moving to the higher value, more complex asbestos-related litigation. The most harmful illnesses being mesothelioma and lung cancer. It's a very niche area. There's not many chambers that do this line of work. I enjoy it because it gives rise to very complex legal issues because of the latency between the exposure to asbestos and the development of symptoms, often up to 30 years. There are a number of difficulties arising with getting the evidence that you need to prove the cases. Mesothelioma cases now, although they've been litigated on numerous occasions at court, the ones that tend to fight now usually deal with cases where the alleged victim has only had very limited exposure to asbestos dust. So the trials usually centre around whether the victim was exposed at all, if they were, whether that exposure exceeded an acceptable dose at the time, and whether it led to a material increase in the risk of mesothelioma. So for those law students, the test for causation is different in mesothelioma cases. Originally, the courts were asked to deal with cases involving individuals who'd been repeatedly and excessively exposed. Nowadays, the type of cases that I see, which are contested, involve very short periods of exposure. So you've got individuals who will have worked as asbestos removers, and whilst they'll have been all kitted out, they will say that there was a short moment when they were in the tent around an area where they were exposed, where they were removing the asbestos, where they took off their masks. I've lots of claims for individuals who were pupils at school where it's alleged that ceiling tiles were dislodged, and that as a consequence, they were exposed on that occasion. I've had one particularly difficult case where we've attempted to argue that a pupil at school was exposed to asbestos because asbestos floor tiles were in the classroom, and the chairs which rubbed against the floor liberated some of the dust. It was a very relieved moment when that subsequently settled to the trial, I have to say. So those are the types of cases that we see. A contentious issue within that area of litigation is funding for a new form of treatment which doesn't cure individuals but can prolong their lives, known as immunotherapy. And the way in which that's funded is an issue that has given rise to a lot of dispute recently. Rich, Leonie's asked, with regard to industrial disease cases, have you personally come across many cases where there is a fine line between owing and breaching a tortious duty and actually committing a criminal offence? And if so, how do these cases usually progress?
That's a good question.
That's a very good question. It's a very good question. Well, the short answer is yes. And there have been occasions, one of which I've encountered, where admissions have been made in court, and that's ultimately led to a health and safety prosecution. But it's unusual.
Richard, I just wonder, I'm conscious of time. I think one more thing that would be helpful is just to explain a little bit about the types of work that we do in PI and ClinNeg.
Yes. Yeah.
I think there's I personally think there's quite a good balance, because we do some court-based stuff, so trials, applications, and that's quite a good side of it. In addition, we spend a lot of time conferencing with medical experts, whether they're clients or actual experts, and there's a good amount of,
isn't it?
Yeah, it is, and a lot of time drafting as well, and whether that's pleadings, so whether we're advising on prospects, we're advising on tactics, particulars of claims, defences. In addition to which, we get to do a lot of mediations and joint settlement meetings, and your negotiation skills come into the fore where that's concerned. Yeah. So for me, I think if you want to be a barrister, it's one of the areas where you do get chance to kind of experience all the things, or most of the things that you learn at bar school, it really brings everything together. Whereas if, for example, you do crime, you're very heavily court-based, or if, for example, you were to do kind of international law, I imagine a lot of that is kind of desk-based. So I think PI and Clin Neg has quite a good mix for me. And, you know, you get to show off all the things, and it's a bit more varied, I think. I know that we're kind of running short on time, but I just wonder whether we can answer some of these questions really, really quickly, because we've got quite a few. Let's just have a look. Does this area involve... Sorry, go on, Richard.
Do we do inquests and public inquiries? Yes, we do. Do tenants of King's deal with any product liability disputes involving medicinal and drug products? Oh, that's a good question.
Well,
Really do product liability stuff.
We also, there's
in the PIP litigation.
Yeah, and there's a lot of cases at the moment with vaginal mesh, which has had quite a lot of bad press, and I've got a number of cases ongoing at the moment, so it's not necessarily, well, I suppose it is product related, but perhaps falls into that bracket. So we do some of that. Let's have a look.
Can we still specialise in this area without a love of science? That's a good question. I wouldn't say I love science, but I suppose you've got to have a basic understanding, haven't you?
Yeah, I mean, I do quite love science, if I'm honest. Yeah, I find it all fascinating. I don't know if anybody's been watching the programme. I know this is a digression slightly, but the programme on BBC at the moment, The Surgeons, I don't know if you've seen it. It's absolutely blows my tiny mind. It's fantastic. So I find it all completely fascinating. And I think you do have to have a bit of a passion for it and an understanding of it. Otherwise, there's nothing worse than being stood, you know, cross-examining an expert and they raise something and you've not got a clue what they're talking about because you've not kind of done the reading around the subject. So there's got to be a bit of that in you, or it's probably not the right one for you. Somebody's asked about statutory limitations of a claim, which we should probably talk about very, very briefly. So usually for personal injury, the statutory limitation is 3 years from the date of the injury, or 3 years from the date of knowledge of the injury. It's the latter which can often attract a little bit more difficulty as to when a person might reasonably have known of an injury. But of course, particularly in relation to Richard's disease cases, that can be many years later that the injury comes on and that they can be aware of it. So limitation, particularly in disease cases, is a massive hot potato, isn't it, really? For kind of personal injury and clinical negligence, you tend to know something's gone wrong after your operation if your arm's fallen off or whatever the case may be. So it doesn't tend to affect us quite as much. The biggest difficulty with that is trying to get everything prepared for a case within 3 years before you've got to issue, which can sometimes be a little bit tricky. Just seeing anything else.
I think there was something we spoke about at the beginning, which was whether there'd been a downturn in work, and someone else has asked whether COVID has impacted our workload. It's quite a difficult one to answer that. We've been very lucky in that I think there's actually been a huge amount of work during the lockdown period and since then. And I think because of the nature of the work we do, with the exception of trials, you can do pretty much everything, either during a video call or on the phone. The court hearings have certainly gone ahead. I suspect that when restrictions are lifted after the winter, I think we'll be inundated with work, because I think you'll find that there's been a lot of medical cases that have just been put on hold. I think you'll find that there have been people forced to return to work prematurely. without the necessary safeguards.
For me, I think it hasn't impacted our work thus far, and I think, as Richard says, we've been quite lucky, because most of our work for PI and ClinNeg is practitioner based and expert based. So a lot of medical practitioners haven't been in work during this period. So the likes of your orthopaedic surgeons have had less work. You know, your oncology cancer specialists have had less work. So they've been much more available to do conferences with us. So the workload for us has been quite steady, I think, throughout COVID. I think the difficulty might come, as Richard says, in cut to 2 years' time, when all of these, you know, tragic cases of people who haven't had cancer treatment, haven't had surgery that they've needed, all then start bringing claims, and inevitably the defence to all of those claims is going to be COVID. You know, the whole country almost has stopped, hasn't it? And I can only foresee that there will be some sort of seminal litigation at some point, which will either challenge the government's view as to what's happened and say, yes, it was reasonable to stop all cancer treatment, or no, it wasn't. And I think that will have a huge impact on work in the next kind of, in the short term, the next kind of 3 to 5 years or so. I think it's going to be quite difficult to unpick a lot of the impact of COVID because of course the standard in clinical negligence is whether the treatment has been to the standard of a reasonable and responsible cancer specialist, orthopaedic surgeon, obstetric doctor. That's the standard. And I think if they're going to say, well, there was nothing we could do because of COVID, that there might be some difficulties. So I can only anticipate that there'll be some sort of huge litigation at some point that deals with that. And hopefully at King's will do it. Who knows? We've gone way over our allotted time now, and we've had some brilliant questions, which has been super helpful. I think from the day's setup, you've all released for lunch for the next hour, and I think at 1:45, have I made that up? 1:45, you're going to be on with Mark Harper QC, who's excellent, and Matthew Hall, who's also excellent at dealing with business and property, so chancery and commercial law. So thanks to everybody that's listened. As I say, it's been hugely disconcerting for us, you being able to see us and us not being able to see you, but thanks for the questions. They've been really, really super. Thanks for listening, and hopefully you'll all join back again at 1:45.